Good morning, and thank you for joining us this morning to discuss a question that is the starting point for all business owners and entrepreneurs. What legal structure will be best for my company and my vision for the future? My name is Johan Strauss, and I'll be the host for the day. I'm a business development director for BTG Consulting, a Mauritian-based advisory firm that assists and advises clients in setting up trust in companies in Mauritius and Switzerland. I've invited a couple of representatives from the South African legal and accounting industry to join me in today's panel discussions. With us, we've got Jack O'Reilly, owner and partner of O'Reilly Law based in Cape Town. O'Reilly Law is a boutique law firm that takes a modern approach to corporate and commercial law. Built on new law principles, they provide quality and cost-effective legal solutions to South African startups, entrepreneurs, and high-growth companies. Good morning, Jack.
Hi, Johan. Thank you. Good to be here.
We've also got Monty Swanepoel, owner and founder of CFO 360 based in Johannesburg. And CFO 360 was born out of the need to have an audit and accounting firm with a difference. A firm where the customer can experience a helping hand navigating you through the complex problems you face each day. In short, where excellent service to the customer is the primary focus. Good morning, Monty.
Hi, Ian.
And last but not least, Boris Pellegrim from BTG Consulting based in Mauritius. Boris holds a degree in law and is a qualified attorney in the High Court of South Africa. Boris has experience in corporate commercial law, international tax, financial services, and offshore structuring. Boris has been living and working in Mauritius for the last 12 years, setting up and advising on suitable legal structures for South African clients. Good morning, Boris.
Morning, Johan. Thanks, guys. Thanks, panels. Nice to be taking part in this discussion.
Great stuff. Okay, so now that we've done the introduction, let's jump into the topic. And the topic for the day is how to structure your tech startup for global expansion. I'm going to ask Jack if you could give us some insights into the structures that are typically being used by your clients in South Africa to start a venture that is potentially looking at going global.
Thank you, Johan. Working with tech startups and a lot of early stage, startup clients, we get this question, probably every month. How can we set up a global structure? And with South Africa's stringent, SARB rules and exchange control rules, it's always been a hurdle for these tech startups, especially tech startups, to get their IP offshore. And what we've advised them in the past is because these corporate structures, international structures, are so expensive, we've actually advised them focus on building value onshore in South Africa. And when you know that your startup is actually going to be a tech startup that's going to be competitive internationally, then you start focusing on building an offshore structure. The structure that we then focus on is there's a couple of international structures that we've helped clients with. These are the typical mirror structures, onshore, offshore mirror structures. And then the question that these startups ask is how do we get the IP offshore? Because we've now developed the IP already in South Africa. And we can go into that a bit later, but essentially it is with the fast pace of tech developments. The South African entity would license the rights to the IP to the offshore entity. The offshore entity would then further develop the IP. And like I said, with the fast pace of developments, the South African IP eventually becomes redundant, and you secure that the value of the IP eventually sits offshore.
Yeah. So Okay. So in terms of, South African-based structures, that's your typical go-to that you will start off, create a PTY limited, and then start the company in South Africa, develop the IP here, and then later on look at going offshore.
Yes, absolutely. You've simplified it. Yes, we would set up a South African company onshore. It's a PTY limited, and the startup founders would operate within South Africa. Develop the IP, and absolutely a separate company would be set up at the later stage offshore, and it would be a parallel company, and we would shift the IP eventually offshore.
Okay, now awesome, thank you. Monty, I think the feedback from Jack on the structures, what do you see are the shortcomings that have been identified and exist in the solutions that we have, that you've got a South African company, develop the IP, and only later you've got the opportunity to look at expanding globally and set up another offshore structure?
Yeah, look, I mean, I think the first one is practical in nature. Specifically when you trade locally and you've got a lot of operations internationally, simply paying suppliers can be a big hurdle. You know, take long lead times to get money offshore to your suppliers. That can also be expensive, right? Cost of currency conversion, dealing with a currency converter, etc. And then often if that happens regularly, you have to start looking at having a foreign currency account locally, which has a certain amount of red tape around it too. And depending on the amount of money being transferred, you also often need SARB approval for funding these entities down the line, number one, and number two, moving large amounts of money offshore. So I would say the first one is practical in nature, and I think that's usually the biggest hurdle, depending on the amount of activity that this entity would have offshore, that they would have to cross by being based locally and incorporated locally.
Yeah. Okay, so I mean, the challenges are that there is administrative burdens to trade in foreign currency. Obviously, you have to set up an account, as you said. You have to get approval if you want to make payments, things like that. But is that enough of a burden for people to say, okay, listen, I want to go offshore? It'll be easier if I don't have exchange control.
Look, having dealt with the Reserve Bank, that can be rather painful. So I would say it certainly is a large factor. There's obviously tax concerns locally. You know, tech structures tend to have higher margins than traditional businesses. So, you know, there's that potential tax benefit of incorporating earlier on. If however, you know, the expectation is there for substantial profits. And then some ownership limitations around that as well.
Yeah, okay. Because I mean, we've talked about the challenges in the South African market if you have to trade globally from South Africa. Boris, if we had to look at something in Mauritius, what are the benefits and the risks or challenges that a person would have before considering moving offshore?
Oh, Johan, I think, look, the normal structures that we've come across when we do structures for our clients from South Africa, they're heavily geared towards creating a lot more substance in Mauritius. I think gone are the days where you just have a nameplate company out there, and then all of a sudden some IP just pops into it. And you know, we try to demonstrate that you know, there was a proper transfer. So I think that these days the biggest challenges to moving offshore for any entrepreneur from South Africa is the cost. Going into any jurisdiction, you've got the cost factors, you've got who do you employ, you've got new markets that you've been entering into. So there's a lot of risks you're factoring into it. But from the Mauritius perspective, it's relatively easy due to the proximity of Mauritius to South Africa. It's relatively easy to set up a company in Mauritius and to operate that company and to do cross-border business. There's very few hurdles and red tape involved in Mauritius. So, for example, the ability to get occupation permits to live and work when you set up your company here is very easy. Latest proposals have indicated you can get up to a 10-year or even 20-year residence permit if you invest into Mauritius. There's no exchange controls. Banking is fairly easy. It's online. It's well developed, the banking sector. The cross-border bilateral trade agreements are all in place, investment promotion and protection treaties, double tax treaties, and also we're part of the bloc, the trading bloc with COMESA and SADC. So, you know, there's not too much complexity in moving your current operation or some of your functions of your current operations in South Africa into Mauritius. But there is a cost factor involved. I mean, it's not totally cheap. The typical structure we always look at is the global business license company, a tax resident company. And to establish tax residence and substance in Mauritius, you need local directorships, you need local audits. You're regulated by the Financial Services Commission. You need a type of infrastructure there to justify your legal economic substance. So it becomes a bit expensive when you do transfer personnel over. But the startup of it is not too bad. I mean, you're looking at running a structure of medium trading, you know, below $20,000. But obviously, if you convert it into rands, it's a big fright. But and the common risk always is if your structure is not properly set up, there's tax risk. That, you know, you could be challenged by you know, the South African Revenue Services, that you're still running your company out of South Africa because you don't have the necessary personnel or legal economic substance in Mauritius, and that could result in double taxation. Yeah, but that's in the tech space. I think a lot of tech startups do use Mauritius as a base for investment into Africa, and they will utilize the tax treaty network to reduce withholding taxes on royalties, which typically happens when you're doing licenses or selling software and services. So yeah, that's okay. You know, that's the general picture we have. Getting the IP into Mauritius, I think, as other panelists have mentioned, is the trick. How do you do that without exchange control and tax ramifications?
Yeah. Okay, no, great. I think, Jack, probably a question that everybody has is tax structuring and setting up a company offshore. Is this tax evasion?
Sorry, repeat that.
Just saying that setting up an offshore company and structuring your tax and your operations through that offshore company, is this seen as tax evasion?
No, it's definitely not tax evasion. If you have economic substance and your place of effective management in the offshore entity, it's definitely not tax evasion. When we talk to our startup clients, we just want to know, we ask our clients why do you want to move offshore? Yeah. And if it's purely to benefit from, you know, the tax treatment offshore, then it might be that it's tax evasion. But yeah, if your why is strong enough, I've read recent articles on offshore structuring, which was a very nice article that I read that was written by a former colleague of mine. If the why is strong enough, then an offshore structure, even with the costs associated with setting up an offshore structure, would make sense. And the why could be that your investors aren't willing to invest into a South African entity. Could be that your market is sitting offshore and you don't want to expatriate that funds back into South Africa. It could be that you have fellow co-founders that's already sitting offshore, and the rest of the founders may be immigrating in any event. So setting up an offshore structure is definitely not, I wouldn't say tax evasion. It's a factual question. You have to ask why. Why are you doing it? Yeah. And then from that question, you'll find the answer on whether it's tax avoidance or tax evasion.
Yeah. Yeah. I guess, I mean, obviously the question is that you have to set up and have legal substance in Mauritius or whichever offshore jurisdiction you choose to go to. And I think the tax rules around the globe is also changing in such a way that it is being more highlighted, especially for tax jurisdictions like Mauritius, BVI, to have the economic substance there. Okay, Boris, in terms of limitations to transferring IP from South Africa to another jurisdiction, I guess, I mean, I've had a lot of discussions with people in developing IP or tech or something like that, and saying it's quite easy to transfer. You just have version 2 and it's slightly different from version 1, and then you'll be able to do that. I guess that's not far from the truth there.
Yeah, I think that's a technique that has been developed trying to overcome the problem where I think in the exchange control rules and regulations, it's quite clear, look, you can't externalize your intellectual property that's created in South Africa out of South Africa without the proper approval through the Department of Trade and Industry and obviously the Reserve Bank. So and that's a very strict policy decision. Intellectual property does bring in large capital receipts, and if all their intellectual property just flooded out, that capital asset would be lost to South Africa forever. So there are strict controls to try and prevent that from happening, and it's a more you require permission. You can't just do it. You require permission. So different techniques have evolved in different places. Look, I mean, the simplest, let's say the cleanest way of doing it is if you did establish your company offshore and you have your proper substance offshore. So we're talking about either your development team, your senior project management team sitting in that offshore company, in that offshore jurisdiction, that's developing that intellectual property, be it software code that they're developing and compiling. I think that's strong because you have the personnel there, you have the key decision person there, the project manager, the key software developer, even maybe some of the finance and operations there as well. I think where it falls flat is if you just have a non-executive director sitting in Mauritius and all this development's being done in the background in South Africa.
Yeah.
And then it's all of a sudden transferred over to Mauritius, and Mauritius has no, on its balance sheet, yes, it'll have IP, but it's on its profit and loss statement, its income statement, it's got no research and development costs. It paid nothing for this intellectual property, and it just appeared on the balance sheet. I think that's where it falls flat. Now, the one technique where they say let's do collaboration. So that often happens. A lot of companies collaborate with universities sometime, and then you have a tech spin-off. You develop intellectual property, and then you can have a joint venture in a company that will exploit that intellectual property. So that theory kind of extracted out and in some advisors saying, look, you can set up this Mauritian company and it will collaborate on the development of the second platform of the software, software version 2.0. But because we're collaborating with a South African company, at the end of the collaboration, the rights to that intellectual property will be shared between the South African company and the foreign company. The foreign company can exploit the intellectual property for offshore markets, and the South African company will exploit it for local markets. And I think that means to try and get away from a physical sale of intellectual property, or a transfer, or even, I hate to even say it, even a donation of intellectual property. That technique seems to overcome those problems. You're not selling, you're not transferring, you're collaborating, and what you've developed is the end product that you can both use. The only caveat I have on that is if you've got no developer sitting in the Mauritian company, no team in Mauritius doing this development, co-development, no research and development costs being paid by Mauritius in terms of either time or actual funding, I think that's where it falls flat. Then it becomes more of a substance over form issue. In substance, you're not really doing development with collaboration, but in form, the South African company is doing all of it, and that's, I think, where it comes unstuck.
Okay. No,
and on that, Boris, the question would be, why would you do that? Why would you choose that structure? I'm just thinking about my typical tech startup client. If we go back to their why, one of their whys would be they want to raise capital offshore because the investor would like to invest in an offshore entity, and an investor wouldn't invest in that in that type of structure because he knows that structure won't own the IP.
Yes,
would just have a right to the IP. So that doesn't solve my clients, the tech startups problem at that point with that particular structure.
Exactly. Look, if you're capital raising, and investors coming into South Africa. Now, South Africa has a lot of, let's say, plus points for investors to come in, which is, very good banking infrastructure, very good law firms, accounting firms, and all of that. So as an investor, if I had to look, I've got a tech company in Mauritius that's going to develop valuable IP, or I've got a tech company in South Africa that's going to develop valuable IP. As an investor, I might consider, let's look at exchange controls. Let's look at BEE. BEE is a big factor. That tech startup will need Black economic empowerment to be able to sell locally, and let's say a lot of government projects. So the decision there might be, I'll have to go in direct into South Africa. I can't go by Mauritius. On the other hand, you might have private equity firms that say, Mauritius has a long track record of private equity investments, retail investments that are easily sellable, and we don't have any exchange control ramifications and BE ramifications. So it's far better, let's do the investments and capitalize through Mauritius, because we understand the jurisdiction, the laws are easy, and they've been tried and tested pretty well. So for capital raising, you might have different considerations. But coming back to, let's say I'm the entrepreneur of a tech startup. My why for going offshore is, can I generate more foreign revenue through this? And I think I can, because IP is mobile. IP is mobile. You put it on a platform, you download it off your Google Play Store, whatever, and you're up and running. You get an income stream. So why would I want to do it in Mauritius? And the biggest factor I find for our clients, it's not a tax driver. We want to earn foreign currency. And one day, we want someone to buy that company, and we're going to make a lot of money in foreign currency terms and not in South African rand terms. Remember, Mark Shuttleworth had that problem. He sold his business. He's made a lot of money in South Africa. Then he had to take it out because he left. He went to the UK. And back then, we still had those levies, the exchange control levies. He had to pay 10%, I think, or 5% to take his money out. And then he challenged it in constitutional courts because the government removed the levy after he paid it, and he took it out. He said, that's unfair. But this is the typical problem. Tech entrepreneurs would look at that Mark Shuttleworth example, and they'd say, well, that could be a problem for me. I'd rather build my tech outside, and I don't have this exchange control ramification down the line. And when I do sell, I'm going to make a capital profit in hard currency, not in the rand, which is fluctuating all the time, in hard currency, which I can then use further for new startups and new tech investments and all of that. So, and tax is rarely a driver. I think we've got so much R&D allowances in South Africa that you can easily be quite tax neutral, starting up in South Africa. But I think the biggest driver is exchange control and ease of doing business as well, because looking at a tech startup who wants to sell in multiple jurisdictions, let's say in Kenya, Nigeria, Egypt, West Africa. Now, the customers can just go online and download the software, but you probably need a marketing team to highlight the brand and all of that. But at some point in time, I want to set up a subsidiary in Kenya to extract more market presence there. I might want to set up a subsidiary in Nigeria and all that. Now, to do that from South Africa is such a hassle, because my subsidiary in Kenya, I have to get bank approval, and then I have to submit all my forms, and I have to fill out a whole form what benefit will be for South Africa. Then I have to do this again in Nigeria. Then I have to do it again in Egypt, and I have to have auditors certify that we are doing what we're supposed to be doing outside of South Africa. And it becomes such a mess that why not just set up this company in Mauritius? And I don't need exchange control approvals to invest in a subsidiary in Kenya, Nigeria, etc. It's easy. I can do that freely without having exchange controls over my head.
Okay, good. I mean, in terms of just running the Mauritian company from a day-to-day point of view, are there limitations? Obviously, as an investor or entrepreneur sitting in South Africa that's running a business offshore, I mean, is there a sense of, I feel a lot removed from our business, it's over there across the sea on another island, I'm not there day to day to see how things are happening? Those are the kind of questions that people would also consider when setting up offshore. Monty, maybe on your side, we are in a more digital business environment these days, especially now with the COVID-19. We've seen everybody being digital almost 100%, or had to be 100% to be able to continue with their businesses.
Yeah.
How can entrepreneurs stay close to their business in that way?
Yeah, look, I think modern technology makes that a lot easier, right? So from an accounting, finance perspective, there's cloud-based systems are now accessible to most companies, however small. In the past, you would have to go through the hassle of setting up a server and hosting an instance, and setting up VPNs, etc. Now it's about as easy as sending somebody an invite on their email, giving them a username and a password and adding whatever two-factor authentication you want, and they've got access to your accounting system, whether they sit in South Africa, Mauritius, Kenya, Egypt. You can all be working on the same instance. So I think practically from that point of view, it becomes a lot easier for you, whether you're sitting in South Africa and you're running this business, you have full access to the financial information of your company, in Mauritius. Yeah. Your staff that are in Mauritius have access to the same information, and often, in tech startups, especially if they're enterprise focused, as an example, they have salespeople dedicated in certain environments, right? So if you want to enter a market and you've got an enterprise focus, you would have somebody on the ground normally doing that business development for you. And that person there has access to be able to generate sales quotes, proposals, etc. And everybody's working on the same instance. So yeah, I think from that perspective, those burdens have been removed to a large extent, or can be avoided to a large extent. And this concept of the remote company is a lot bigger these days. You have, I think the theme till now has been mainly focused on tech companies. There's some very big examples of companies that have been built entirely remotely. I think WooCommerce from Cape Town was an example. There's a code hosting service called GitLab. There's about 2,000 staff, all 100% remote.
Jeez.
Everybody working on the same instance. So that kind of operational requirement is entirely possible, and it's possible for even much smaller entities these days. At the startup phase.
Yeah. Okay, but I mean, obviously, from a tax point of view, you still need your physical substance to have happened in the remote jurisdiction, but at least the ancillary tools to allow you as an owner sitting in South Africa that have your sales team or your managers in Mauritius, at least you don't feel as far removed from your company as you might have been in the past. As you say, you've got all these tools that allow you to connect with your company more clearly than in the past. Yeah.
No, absolutely. I mean, us as an example, as a firm, we've always been 100% remote, and to be quite frank, COVID hasn't affected us at all. In fact, we're deciding whether we still need as big an office space as what we've got at the moment, because when we asked the staff whether they wanted to come back, they said maybe. So yeah, I think that, you find there's different ways to connect with your people and manage your team. And there's a host of tools, whether that be Zoom, project management tools in the middle, cloud-hosted accounting packages, and financial software. Those tools are all there, and I think they're experiencing some rapid adoption at the moment. And it opens that kind of worldwide possibilities. We have a number of clients that we service from South Africa that are entirely not based in South Africa. As an interesting example, one of our clients is an accounting firm that focuses solely on UK businesses, 100% from South Africa. If they were as tax sensitive, or they enjoyed the beach a lot more than perhaps the South African Joburg environment, they could just as easily have been based in Port Louis. Yeah. Right. And their clients would not know the difference whatsoever. So yeah, those kind of possibilities are entirely there. And I think, it's much easier these days than what it was in the past to remain connected and to manage that team than historically.
Yeah. So
just to add, Jan, I think what Monty has said is quite important. When you think about moving infrastructure and personnel, especially in the IT business, that you don't need an army of people in Mauritius. This could be a chief technology officer, it could be a marketing manager that bases themselves in Mauritius to create that substance. And that could drive the product, because you don't need a lot of infrastructure. As far as servers are concerned, I mean, you can where you use your database servers and your transaction servers, that probably would be recommended be outside of South Africa. But from a technology business perspective, yeah, the infrastructure would not be too big to set up.
Yeah. And I think to add to that, people usually compare the cost of Mauritius to, say, cost of South Africa. But you would have to appoint that person in any event. You will have that person in South Africa. And setting him up in Mauritius, you might have a little bit of extra expense, but you'll still have to employ that person to do that work for you.
Exactly. I mean, it's the cost of an occupation permit for 3 years, and then you get a 10-year permit after that. And then the cost of relocation and setting up that person. And then there's good quality staff in terms of IT, administration, accounting. I mean, that's what Mauritius has been set up as a hub to be able to do all of that. So the human resources side is, you can also employ locally, but yeah, you'd want your senior management at least to come over, and then live in Mauritius. And
okay, so someone of the team needs to pack up their bags and move to Mauritius.
I think that's a recommendation, definitely.
Yeah.
Ideally, yeah.
Okay.
Yeah. Okay,
that's the main question, because a lot of clients think that they can set up the structure and like you said earlier, you just have this shell company offshore, and that's not the case. Someone will have to move.
Exactly. I think you'd fall flat on the substance issues. I mean, like I said, when you look at where's the mind directing this company from, where are they based, where you normally say, no, it's the board, and the board is meeting in Mauritius. That's not enough. We know the South African test is place of effective management, and we've got a tax treaty with South Africa. So there's additional requirements in terms of that tax treaty, and there's a memorandum of understanding that is issued. So you can't have that nameplate, that nominee directorships in Mauritius. And what the attractiveness of Mauritius, it's so close. It's a 3.5-hour flight from South Africa. For example, you try and do this in Hong Kong, different time zone, and let's say you're going to set yourself up in Hong Kong. Well, let's set yourself up in Delaware. It's very difficult if your target market where you're going to be selling your software is Africa. That's your target. It's very difficult to, in different time zones, different infrastructures, different permits in different locations. It's extremely difficult. It becomes very expensive and not very well operationally managed. Meanwhile, Mauritius is in that time zone, almost as exact, 2 hours ahead of South Africa. When business is winding up in the east, Mauritius is still operating, and then when business is starting up in the west, Mauritius is closing down. So the ability to move to Mauritius, the connectivity with the flights, hopefully post-COVID, that's all right, and we'll have airlines that are working again and not under demonstration. But it's there. It makes common sense to say this: if my target and my market is in Africa, Mauritius is the logical place, but I need to move my key decision makers to Mauritius. We've got the examples of Aspen Pharmacare. They've got 120 people. They're all Mauritian, but I think the key senior management's South African. So you have them based over there, but you don't have to be a multinational big company. This is, I think, what we trying to also explain to listeners. You can be a small startup and still be successfully do this and set up in Mauritius, but in steps. It's not all going all at once. You have to go through a step process to be able to grow your market, because you are a startup. You might fail. And to pay a lot of money and send a lot of infrastructure to Mauritius in year one might not make sense. You'll waste a lot of money because you don't know if you're going to make it. But let's say in 3, 4, 5 years, you see that cash flow coming in from all the license sales and purchases of software. I think then that's the logical step to say, okay, now I need to bring that infrastructure in. Now I need to put senior management. I need to build the operations over there.
Absolutely. It's a phased process.
Yeah. I think that leads into my next question, Boris, is that you're looking at startups that's developing technology, software, or IP. So they wouldn't normally be able to set up such a structure in terms of cost. And the challenge is finding an innovative solution that is both cost effective, but doesn't limit the ability of the entrepreneurs to manage their company and their global expansion. So are there any alternatives to the ones you mentioned? I think you said the global business license, which would cost you up to $20,000 a year. Any alternatives to those structures that would be able to be a solution to these types of startups and tech development companies?
Yeah, I think the solution presented itself to us when Mauritius moved away from a very broad tax benefit offering that they had. They had to get in line with the OECD and the EU, where they changed some of their tax rules on how these global companies are operating. They got rid of an old legacy system and they instituted a new system, where now you just basically have a tax resident company or a non-tax resident company in Mauritius. And this is for foreigners to use. Now, for the tax resident company, that's the type of company we're talking about that's very expensive, because the company alone, even with an outsourcing arrangement, costs about 20,000. You haven't put people in Mauritius yet. That can cost you even more. So obviously that cost grows. So a tech startup would say, well, that's too expensive. I can't do that. I'll just, what's the alternative? The alternative is looking at this non-resident Mauritian company. So it's non-resident under Mauritian law. And it's a funny system why it's non-resident. For a company to be resident, tax resident, it's called a tax resident in Mauritius, it has to be incorporated, or it must be central management and control must be in Mauritius. One of those two. It's a bit different from the second test, is a bit different from South Africa. South Africa's test is where's the place of effective management. Central management control looks at board level decisions, key decisions being made by a board. So the Tax Act in Mauritius has changed to say, listen, if you're a non-resident company, if your central management and control is not in Mauritius. Okay, so that's it. And then in the Financial Services Act, they've made a specific provision for something called an authorized company, which is a company which its central management control is not in Mauritius. It's somewhere else. So now you get to see, okay, well, I've got a company that's not tax resident in Mauritius. What can I use it for? And we went through various permutations. We actually stumbled upon saying, well, why can't a South African use this company? Why can't they be the sole shareholder, sole director on this company and simply run it from South Africa? So we'll be tax resident in South Africa. So we know we're not tax resident in Mauritius, so we don't have this risk of double taxation. We're not going to have the Mauritian government tax us because the Mauritian government is not tax resident here, so it doesn't pay taxes. It still has to do some filings. It still has to file a financial summary. And funny enough, it has to file a tax return, but it's not going to pay taxes. But let's make it tax resident in South Africa, because I'm going to run my board meeting in South Africa. I'm going to run this company from South Africa. I'm going to incorporate a Mauritian company. I'm going to open a Mauritian banking account for this company. I'm going to run it from South Africa. And I'm going to go and register it for tax and VAT in South Africa. I'm going to go to SARS and say, I'm going to sit down at the branch offices and say, here's my company. I'm running it from South Africa. It's a Mauritian company. Please register it. I mean, I'd love to see the SARS official that was what? But let's register it. If you don't register it, well, great, then I won't pay tax. But register this company and let's now make it compliant for tax purposes. Okay. But I still got an offshore bank account and an offshore company. Now I'm going to operate this company from South Africa. I can make all the decisions. I don't have to have a Mauritian board. I can run it easily. And I don't have to have the cost infrastructure of using outsourced service providers who will provide the back office and the accounting and bookkeeping function. I can run it from South Africa. I can hire my accountant to do all the bookkeeping, accounting, and I can do all my own resolutions and all of that. So we found, look, there's a place for this type of vehicle if we used it in this manner. But you might ask, what's the benefit, And it comes down to earning foreign currency. So there's no tax benefit. I'm still going to pay South African taxes on my income. But I'm going to bank my income, the dollars I've earned from sales, I'm going to bank in Mauritius. I'm not going to bank it in a South African bank account and convert it to rand. And that's the attraction we see with this type of vehicle, to say, okay, well, the tax angle's all checked out. I will pay South African tax, good. I'm going to do all my research and development in this company as well. So here comes the legal angle. I'm the brains, the idea is in here, and I'm working for this company. I'm going to be the director of this company. When I'm finished with this intellectual property, by common law, it should belong to the company. I don't have to sell it to the company. I've worked for this company both as a director. I might be an employee as well. But by common law, the feature of this intellectual property will be owned by the company. So if I have to register copyright on anything, it's going to be in the company's name. I haven't transferred physically any intellectual property offshore. And this is where it becomes interesting. I mean, one could argue there was a transfer. Company and it's sitting in the foreign jurisdiction. If you sell this company shares, the money is going to be banked offshore, and now we've gone past exchange controls. That's debatable. I mean, that's a debate. Did I transfer intellectual property offshore? No. Do I have to register this company as an external company? The Companies Act. Probably yes. I think we had a discussion just recently. I'm thinking, well, if we look at the definition of it, not the definition, but the external company provision, the Companies Act in South Africa, it says, well, if I'm going to hold my board meetings and my shareholder meeting in South Africa, I need to register as an external company. So we'll have to go through that process. We'll register as an external company. We'll register for tax. I think the third question is, are we an exchange control resident? And this is where it becomes debatable. The fact that I've registered an external company in South Africa, due to the fact that I'm going to hold my board meetings here, does that make me an exchange control resident? I think not. I mean, I think if I look at the exchange control manuals, you can pick any one of them, either for the authorized dealers or for individuals or for corporates, and you look at what is non-resident definition. If the registration, let's call it for corporations outside of South Africa, then this vehicle is a non-resident exchange control purposes. But I don't think we have to register for exchange control. And even if we did, what would the effects be if we had to now go and say to and how do you register for exchange control? I think the only logical way is you have to walk into a bank to say, I want to open a local bank account for my Mauritian company. And then the question of exchange control and blah, 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 you exchange control resident. But we don't need a South African bank account. We've got a Mauritian bank account. We've got a dollar, euro, yuan, doesn't matter what currency bank account with a tier 1 bank in Mauritius. So I don't think it'll become an exchange control problem. But now this company is not going to cost me a lot. I'm going to have to pay my registered agent. You have to have a registered address in Mauritius. But that's about it. And it'll probably cost you between $3,000 to $4,000 per year. Let's say to run that, to have that, let's say that registered office, registered agent base. Because the registered agent has to do your filing. They have to file a financial summary to the regulator, which is still the Financial Services Commission, and to the registrar of companies, and they have to file their income tax return. So the registered agent has to do that. They don't physically have to do the work. They can get all the documentation from the accountant, and they just upload everything into their system, because it's an online system that the registered agents have to use. So we brought the cost base from $20,000 plus down to, let's say, $3,000 of operating this company from South Africa. We'll pay South African tax. And then you've got some permutations, which we can bolt onto this type of company. We can add a trust. We can add a foreign trust. It doesn't have to be a Mauritian trust. It can be a Guernsey trust, a Swiss, Isle of Man trust. It doesn't matter. If the trust is a shareholder of the company, we get into some interesting permutations now as well, because when we want to declare our dividends, okay, when we want to declare dividends, it's going to go to a trust in Mauritius. Now, a trust in Mauritius is considered to be a company under its domestic law in Mauritius. If we look at the tax treaty between Mauritius and South Africa, a company that is declaring dividends, there's a withholding tax obligation. And if the dividends are going to another company offshore, there's a withholding tax obligation. And that's usually under South African law, it would be 15%, can be 10, it can be 5%, depending on shareholding. What's the shareholding amount in the South African company. In the South African company. But here we're dealing with a Mauritian company that's paying South African tax, but is declaring a dividend to another company / trust in Mauritius. So we feel that the withholding tax drops from 20%, the dividends tax, down to 5%. So you've got a tax benefit creeping through if you modify the structure a bit. We're tax compliant now. I don't have to build substance in Mauritius or lie about it. I'm tax compliant. I'm paying South African taxes, so I'm clean. And when I declare my dividends, that's off. That's net of withholding taxes. I've already paid tax on that. When I take it out of my trust, later on, I've already paid tax on it. It's exempt dividend coming back out. I'm not going to pay tax twice. And then ultimately, when I want to sell, if I had that big buyer from the US or Europe who wants to buy my company, my tech startup, my trust will sell the shares. I'm not going to do it. Now, you don't need the trust. Honestly, you can hold the shares directly. You can hold the shares directly, and you can manage this whole company out of South Africa. You can get the dividends out, but then there's that dividends tax of 20%. It's a South African tax resident declaring a dividend to yourself as an individual and tax resident South Africa. So you're going to suffer the dividends tax. But remember, net after that dividends tax, that money you can open a bank account in Mauritius, a private bank account, and you can park the money in there. You don't have to bring it back to South Africa. You're allowed to park it offshore because let's say you funded your company through your foreign investment allowance. You're allowed to keep it offshore. And then if you ever sell the company, that profit can be booked offshore and paid into your Mauritian bank account. You do not have to return those profits back to South Africa. Remember, it's not an exchange control resident. It's tax resident. We'll pay our taxes, but I think with a little modification, we bolt on a trust onto this vehicle. It becomes very tax efficient, asset protection, estate planning wise, it all works. But the biggest feature of this is, look, I don't have to have a big infrastructure offshore company and pay a lot of money. I can pay the minimum I need, $3,000, and I can run this company from South Africa and I'll pay my taxes and my dues. But I'm getting this benefit of exchange control offshore. I did say it's debatable. We can debate the exchange control issue. Personally, if I look at those manuals and we say what a non-resident is, my argument is I'm not an exchange control resident. Even the fact that I have to register me as an external company. I'm not going to a bank to open a local banking account. So I'm outside of those realms. There's no form I fill in to become an exchange control resident. So I think I'm out of that game, and it's debatable. I mean, we can debate the ramifications and see, look, do we agree? And if we are exchange control resident, what's the effects? Because we're not managing capital flows moving out of South Africa. The capital in Mauritius, already there, it's been established through my foreign investment allowances. If I make this company exchange control resident, what am I monitoring? There's no capital flows out.
Yeah. I mean, to sum up, I mean, you're talking about an authorized company that's tax resident by registration in South Africa, but the company is registered in Mauritius and has a Mauritius bank account. So you comply with what South Africa, in terms of needing to register because your effective place of management would be in South Africa because you're running the company. But you also have the ability to trade offshore without restrictions because your bank account sits in Mauritius. Okay. And then obviously from a shareholder point of view, you said you can either hold the shares yourself in South Africa, but that would make it that you are taxable in South Africa for any gain or if you sell the shares, or you can have a trust that holds the shares offshore that ultimately, if there's a international buyer coming through, the trust would make the capital gain.
Correct.
And just a question, and when the trust, so yes, you hold the shares through a trust, the founders set up a trust and they are the beneficiaries of the settlers and the beneficiaries of the trust, and the trustees then make a distribution to the founders. How would that be taxed? if considering they are still South African tax residents?
So if we got dividends, it's not a foreign dividend anymore. So if we got paid dividends, it depends what's the class of income we're looking at in the trust that we make.
Okay.
So you've got the flow through benefit.
So say it's a dividend and or a sale.
Yeah, so if it's under the conduit principle, we're saying, look, I've got a dividend. It's not a foreign dividend. It's a South African tax resident company. So it's a local dividend that went through. Withholding tax was withheld. When it hits this, the trust, we're sitting with now exempt dividends. So when I distribute that out again, I'm not going to pay tax on that again. Okay, so that's for the dividend side of it.
Okay.
But let's say the capital gains side. So I held the shares. The trust sold, the trust is tax resident in Mauritius, the trust sold the shares. As long as I don't have a property holding IT company and a permanent establishment of the trust in Mauritius, in South Africa, there's not going to be any capital gains tax payable in South Africa. So the trust as a non-resident doesn't pay capital gains tax on the sale of those shares. So what we know that class of income inside the trust is capital gains. Now when we vest that out, we're going to retain its nature. And we're going to pay an effective rate of, what is it, 18% for capital gains. If you're at the top marginal rate, you're going to include that capital gain in your income, and you're going to have the inclusion rate applicable to it, and your effective rate basically comes down to 18%. So our dividends would be exempt, capital gains 18%. When they come out of the trust, if you're not making the payment out of the trust, there's still no tax, so there's a deferral. You're waiting, SARS waits for that money to come out. Doesn't matter where you pay it. You can pay it in Mauritius, you still pay the potentially tax in South Africa if it's a capital gain. But you do your normal disclosures like you do in your income tax return. I've got exempt income, here it is. Bars will know about it because they saw the dividend going out and paid withholding tax. And then capital gains, here's the capital gains receipts I received from the trust.
Understood, thank you.
Okay. Yeah, any other questions regarding the structure that we've talked about from any of the other panelists?
I just have two questions, Boris. You speak about the CGT, and obviously the nature of trust is always that conduit principle, right? And often, I would say most of the time, trusts are registered as non-vesting, right? So discretionary vesting trusts. Presumably, often if there is a windfall, right, and an entity is sold and those profits remain in the trust, presumably the South African taxes would only be taxed to the extent that it's vested. So, you know, there's no obligation to fully vest any windfall. And that's my understanding of it. I just want to make sure that's yours too.
Correct, Monty, yes. I mean, the trustee still has to exercise the discretion to benefit one or all of the beneficiaries.
Okay.
So that's only when that discretion is exercised, that vesting takes place. Before that, there's no vesting. So it's a fully discretionary trust waiting for the trustee to exercise the discretion. So then it's not taxable. On the Mauritius side, from the trust perspective, as long as the settlor, the South African settlor, and or his beneficiaries are not tax resident in Mauritius, so they haven't moved to Mauritius, that trust, we file a declaration within 3 months of the financial year end of that trust to the Mauritius Revenue Authority, declaring that those conditions are present. And then the Mauritian Revenue Authority for that particular year, that tax year, will treat the trust as exempt from taxes. If you fail to file the declaration, obviously it has to pay its tax. So those are the conditions. The founder's not here, the beneficiaries are not here, and you filed your declaration. But if you fail, then you're in a taxable position. So every year, all the trustees are filing those declarations, and the trust doesn't pay tax in Mauritius. So officially it does, but to the extent you file the declaration, the conditions are met, it doesn't pay tax.
Okay. And then just another question. I think, you know, to a large extent, the discussion has been around IP-heavy companies. Are there benefits for potentially a different type of company, right? That's perhaps not as IP-heavy, builds more towards a brand, professional services, or any kind of company that's perhaps not IP-heavy? I imagine, you know, from our discussion, a lot of the benefits would be similar, but I'm sure there's some permutations to that.
No, I think across any type of company, I mean, I think we focused on IP in this discussion, but this can be extracted to any type of company. Now, just the one caveat is that the company, the Mauritian company, should be used for the sale of goods and services outside of South Africa. Because I think as soon as you do it inside, I think then the technicalities start arising about, maybe then the exchange control issues could arise. So, okay, well, I've got a South African company now that has to pay this Mauritian company an offshore banking account. The South African company has to go to its bankers to say, send the money across. And then that, that could be an indication, wait, you have a Mauritian company that's doing business in South Africa and shouldn't be registered. And I still don't think so, but I think there is that added complexity. But once you've got this Mauritian company, you should be only doing your sales outside of South Africa. Use your South African company for your local sales. So you'll have two companies. You'll have your South African company doing everything locally. But for all the offshore sales in goods or services, use the Mauritian company and bank the profits outside of South Africa. Pay the tax still in South Africa, and I wouldn't link the two up by saying the South African company will do an investment in the Mauritian company. Then you still need exchange control approval.
Yeah.
And that would be interesting. I'd love to see how that would work, but you still need exchange control, banking approval to say I'm investing in a subsidiary. It happens to be paying tax in South Africa, but I still need the approval. I'd still keep it separate. And the funding mechanism for capitalization of the Mauritian company would always be you use your foreign investment allowance. Use your 10 million or your 1 million discretionary allowance, and that would be your capitalization. So any working capital, you would have taken out the right channels and deposited it and bought up your equity in that Mauritian company. But the only difference is your Mauritian company is going to be paying taxes in South Africa, which is what we want. We want to put into that state. So yeah, I mean, it can be across the board. I think the interesting part of the tech startup is if that transfer of intellectual property took place to the Mauritian company. That's quite interesting. So if you worked and did your R&D in the Mauritian company's name, purely the IP transferred over under our IP laws or general IP laws. It transferred over. It's copyright. If not, there still have to be a sale. And then it gets a bit tricky. Are you selling to an offshore non-resident and things like that? I think that's debatable. I think from a services perspective, it's easy. If you're doing consulting services and consulting across Africa, the perfect vehicle, just use it. Your customers will be paying directly into the Mauritian banking account.
Also 2 questions. How would we go about to get certainty that this Mauritian entity owns the IP and that Saab accepts that this Mauritian entity owns the IP? Because we're debating it. Has Saab made any comments on this structure?
So yeah, we haven't approached Saab on it. We are approaching a separate law firm on it to say, look, we want the security that we don't have to have. I think the problem is if we do have to register as an exchange control resident, but it becomes such a funny issue if you do that, because then technically, how do you monitor capital flows? Like I mentioned, it becomes nonsensical because you're not moving capital out, you're not dealing with rands, you're not moving capital in and out. So it becomes a worst case scenario. They might say, no, you're not allowed to. You're not allowed to run this operation, which is strange because SARS is getting the income. SARS is getting money. You're creating money for SARS, and you're paying it in dollars. Perhaps you're paying that money in dollars, so you're bringing forex in. So for those 2 institutions to maybe not cooperate in allowing this would be highly unfortunate and a bit problematic, I think, in terms of what the legislation is we currently have. But we are approaching a law firm to say, let's get certainty on it. It's difficult to approach the exchange, I think the Reserve Bank, because Reserve Bank works on a case-by-case basis. So if you have this case, you have to do an application and we'll go forward with it. So I don't think there's any opinion the Reserve Bank would offer on it.
Okay.
But yeah, I think that's the best way to approach it. So when clients do go forward with it, there is that comfort, both angles were checked.
Okay. Second question was that the Mauritian entity, I'm assuming, won't be able to own the SA entity, right? Because that would then...
Yeah. I think if you're still holding on to the non-resident concept of the Mauritian company, if the Mauritian company owns it, you're in a loop transaction. Intended or unintended, doesn't matter. So that could be problematic. I know the exchange controls have been relaxed to say, look, you're allowed to have a South African 40% element. And that might be helpful later on if you get a PE investor or something to say, okay, well, PE investor takes up your 60%, you remain the 40%, and we'll allow the loop. And we go through that process of applying to the bank. I think that would be worthwhile. But before that, not being 100% owner would be a problem.
Yeah. Boris, just a question from my side. I mean, you said earlier that you've got the authorized company that now develops the IP, and you've got your South African company that basically does operations in South Africa separately. Would you then license that IP to the South African company? Because obviously the IP was developed in the Mauritian company, and you do want to access the South African market as well.
Jan, look, I think what I would do there is not sub-license, that I'd still do the collaboration, because I'll still need my people in the office in the South African company to collaborate in the development of the IP. I might be the only, so I'll be the sole shareholder, sole director, and the business owner of the South African company in both. But I'll provide the intellectual capacity for the collaboration and development, but I'll still have my team in the South African company doing some co-development. So we'll have to co-develop it, because I wouldn't want to sub-license down, which means the South African company has to pay money offshore. And then you need DTI approvals, you need exchange control, you get to go through the banking approval, and that's tricky. I'd rather do a collaboration where we, at the end of the development, so we've got our software now. At the end of the development, the authorized company will only exploit this IP offshore, and the South African company will only exploit this IP onshore.
Yeah.
And there's no cross-licensing. When we have to go to version 2, we'll collaborate again in terms of funding or intellectual capacity, or how this must be done. But we'll always do it under a collaboration agreement. We'll co-develop this. We'll have a formal agreement between who does what, and who project manages what. But at the end of it, we both own the line. We both own the intellectual property rights, the same software.
Yeah. And just another question. Okay, so now you start with this company and you run it in South Africa, and you go global, and it's a huge success. Now you want to change your place of effective management. So you decide to move to Mauritius. Can you then re-domicile that company, become a fully fledged Mauritian company, have substance, all of that?
In theory, yes. So I mean, in practice, never been tested, but in theory, yes. So again, you have to play within the tax rules. And what's nice about the tax rules is we do have an overarching tax treaty. Because if you don't have a tax treaty, it would be difficult. With a tax treaty, if you look at the South African Mauritian tax treaty, what I could do is make this authorized company. And I remember the authorized company is just a normal company with a license on it from the Mauritius Financial Services Commission. If it's got the authorized license, it's not tax resident in Mauritius. If it's got the global business license, then it is tax resident in Mauritius. But we'd have to do a bit more than just getting the license. We'd have to now move our key decision makers, our chief technology officer, our marketing manager. We'd have to say, okay, now let's shift them to Mauritius. Let's build that substance, that office. Let's set up offices now. And now what will happen is there's an exit out of South Africa. So you have to have this, you can't be tax resident in both jurisdictions. We can accept that. And the way to figure out where are you tax resident, you have to use the tax treaty to help. And the Mauritian South African tax treaty have kind of did away with the place of effective management, said we have to have mutual agreement. We have to have a MAP process, mutual agreement process. So the two revenue authorities have to talk it out, where is this company tax resident, looking at all the factors. So under Mauritian law, if your central management control is in Mauritius now, I'm going to have my board meetings, I've got a GBL license, I've got personnel in Mauritius. Under Mauritian domestic law, it's tax resident. Under South African domestic law, you have to look at, has the place of effective management shifted? We're not looking at incorporation, because we know it was incorporated there, but has the place of effective management shifted from South Africa to Mauritius? If it has, and we mutually agree with the Mauritian Revenue Authority it has, then we now tax resident in Mauritius. But there's a trick to it, there's a catch to it. If we break South African tax residents, there's something called the capital gains tax exit charge. I'm deemed to have disposed of all my assets just before I've left South Africa. Now, it happens with immigration with individuals. Technically, it should work with corporates as well. So that company, that Mauritian company, has to pay capital gains. And you do a valuation of your assets on the day you started and your valuation of your assets and when you're leaving. And the difference is a capital gain and included in your income. And you're going to pay taxes on it. But it is if you do pay your taxes on it, it's a clear indication. I've left South Africa, I paid my CGT exit charge. And I'm now in Mauritius. As long as I have my substance in Mauritius, technically you can shift it. But if you do this too late in the game, obviously it's going to be a massive capital gain.
Yeah. Okay. No, excellent. I think definitely a lot of things to consider and talk about. I think we're running out of time at the moment, but if there's any other questions remaining that any of the panelists want to ask, let's do the last question and then wrap up.
I don't have any other questions, Johan. Just from my side, thank you for having me, and Boris, a very insightful input that you gave today, and I certainly learned a lot, and you answered a lot of my questions that I had about this new this structure. So thank you for your time, and Monty, thank you for your time.
Thanks, Jack. I mean, I have one more question, Boris. Just, you know, we spoke about the CGT being largely exempt, especially if it's owned by a Mauritian trust. And you know, a few moments ago, you spoke about changing the place of effective management and that effective CGT exit charge. You know, and obviously you have full right to plan your exit in certain ways. Is there a permutation where you avoid the exit charge as such, or can plan the operation to do that?
I think, I mean, you can avoid it, and maybe preferably it is that you can avoid it and don't try and don't try and move your place of effective management out, because at the end of the day, if the trust does the sale, it's clear the capital gain won't be taxed in South Africa, provided those conditions are there, that we're not holding a lot of property in that company, and at the same time, it wouldn't be, it's tech. And then we don't have a permanent establishment, we don't have an office place of management, and things like that, for the trust in South Africa, which we won't have. That will never happen. So tactically, it's far better. Look, leave it as is. But tactically as well, if you are in the tech startup space and in 5 years you see, look, this is growing, and I have now the ability to leave and go, because remember, I still won't pay tax, even if I'm a tax resident in Mauritius, if I do the sale. You might want at that point in time say, look, in the next 5 to 6 years, my revenues are really going to escalate, and I don't want to pay too much South African tax on that. And I have the ability now to move, and I want to move. Then you do it, but you wouldn't do it at the end. You wouldn't do it when there's so much value in that company. You do it somewhere just you're pre coming into good profits and cash flows, where you decide, okay, let me do it. Let me go through the ramifications of doing the exit charge. Going through, it might be a 2-year process for all we know. The mutual agreement process isn't easy. So it might be quite a process, but you'll go through it. And then once that's done, our future revenues are only going to be taxed in Mauritius at 15%, not the 28%. So that might be a consideration. But tactically, you might say, because I don't want to pay high infrastructure costs or stay in South Africa. It's just the time.
Yeah, gotcha. Thank you.
All right. I think that's all that we have for today. Boris, Jack, and Monty, thank you very much for your participation and your insight. We're definitely looking forward to exploring this opportunity further, and to answer any questions that you guys or your clients might have.
Thanks a lot. Thanks, John. Thanks, Jack. Thanks a lot for having us.
All right.
Thank you, Johan. Thanks, Boris, Jack. Appreciate it.
Have a good day.
You too. Thank
Thanks.
you.
Bye
Cheers.
bye.